Hello, ma. Hello, ma. Hello, ma. Yes, ma. Okay, ma. Ma, please join now, ma. I've moved them to. Okay. You can comment. So I'll pick the link now and send it to them now to the chat. Ma? Okay, ma. Okay. Okay, ma. So as it is now, with the drop link here is in their chat now. So I'll also send it to. You will see the numbers. Yes. You okay? I will also be on YouTube so that I would give you updates through maybe chats that they are here now. They are yes, yes.
I appreciate the courage you put up to call up this interview. You've asked me to give at least 5 things that make a chat group active, but I will give you 9.
Hello, I can't hear you.
I'm not speaking because I'm not speaking. Can you hear me?
Yes, ma'am.
Yes, I can hear you.
No, I was not speaking because we still have 99 people on YouTube. That's still not a big number. Because that's still less than 2 departments, right?
Yes.
Am I correct? That will still be a number that will be less than 2 departments. And you have what, 5 or 6? How many departments? 5 or 6?
7.
7. Can you tell me what these departments are? I thought we had 6. Do you have an extra department, additional department? I'm also monitoring students on YouTube, and I want that to be a good number. We don't want 400 students when we have over 1,000 of you. Are any of the class representatives here?
Yes, ma'am.
If you're a class representative, can you can just open your mic and tell me what department you are representing.
Right. Good afternoon, ma'am.
Yes.
I'm Ephraim. I'm presenting accounting department.
Okay. Have you reached out to your colleagues so that they can join
Yes, ma'am.
the class? Okay, because we still have a small number on YouTube. Do you know how many of you are in your class?
Yes, ma'am. We are about 300, ma'am.
So accounting is about 300.
Yes, ma'am.
Accounting is 300. Yes, which other class rep is here? Just about 300. Maybe a little bit
Hello, ma'am.
less or more. Yes?
Yes, I'm Adewumi, for class governor of business administration, ma'am.
Biz admin.
Yes, ma'am.
Do you know how many people we're expecting in your
Yeah,
class?
we're about 250 students in business
250.
admin, ma'am.
So we don't have access to your registration. I don't know how many of you are in the respective departments. Okay?
Yes, ma'am.
Yes, any other
Good afternoon, ma'am.
insurance? Yes.
This is Actuarial Science representative,
Act-
ma'am. My name is Chioma.
Actuarial science is now, it's not the same department as insurance, right?
We are the same, but we
Yeah,
are
so
separate.
because I want to. Okay, so how many students from actuarial science?
In Actuarial Science, we are about 138.
138.
Yes, ma'am.
Insurance?
We are 210, ma'am.
And insurance. Okay, thank you.
Good afternoon, ma'am.
Good afternoon.
This is Pelumi. Taxation is also under accounting. We are just a class of 9 students.
Okay. Oh, that's why you are 7 departments now, right?
Yes.
Is that
Yes,
okay?
ma'am.
So, well, that just means we have additional 9 students. It doesn't reduce the number of students we normally get. Okay.
Yes.
Then, which other department is here?
Good afternoon, ma. Business education, ma.
Okay. That's normally a large class, right?
We are 141, ma.
Oh, not so large.
Yes.
Yeah. Okay.
Good
Which
afternoon,
other
ma'am. We have
department?
finance
Sorry?
department.
Okay, finances. How many students? Do you know how many students are in your class? Finance.
There are about 250 students, ma'am.
250. Okay. So let me just confirm with my colleague what the number on YouTube, but since I have a rough number here, then I'll know if we have a fair number and we can go on. Because it may not be fair if others cannot join for maybe some reason that is not their fault. And then I teach like even less than a quarter of the class. Hello?
Yeah, with
Ma.
you.
Okay,
No, ma'am.
okay. So yeah. So
Hello.
I So based on the figures you gave me now, I see that we have close to 1,500 students. And I just spoke with my colleague that I'm going to give extra 5 minutes. So if the class reps, you want to rally your classmates and give them the link, the class will start at 12:40. And I'm giving that much time because at the beginning, we had to we needed to make the YouTube link happen. So I'm just saying, because it was not your fault at the beginning, but yeah, if you can't join after the link has been given like 20 minutes or thereabout, then I have to assume that these are people who are not wanting to join the class at all, and I can start. So if you tell them in 4 minutes, the class will start. Is that all right?
Yes,
Understood,
ma'am.
ma. Wow. Oh, this guy, fine, sure.
Yeah.
Okay, so we can start. Can I ask you all to mute while the class is going on? Okay. Okay. Okay, so good afternoon, everyone, and welcome to the business law class. I hope I'm audible.
Yes, ma, you are.
Yes, ma'am.
Okay, so my name is Dr. Adekemi Omotubora, and I'm the lead lecturer for business law. So I don't know what you've heard from your predecessors, your colleagues who have taken this course in the past. But what we try to do is to introduce the students to the broad area of business law, knowing that you guys are from business management or management sciences, right?
Management
So you are
Yes,
science.
from
ma.
the Faculty of Management Sciences,
Yes, ma'am.
and some of you are doing business related disciplines, business related courses. So this is an aspect that is important for some of the your ambition to become different, to be in these different disciplines, to be insurers, to be business management people, actuarial scientists, accountants, tax experts. What do you call people who are who do taxation?
Taxes.
Taxers. Oh, that's a first timer. Is that really it, or is that a coinage? So, anyways, those of you who are going to be practicing tax or taxation, people in business education, those in finance. So what we do is to give a broad overview of the different kinds of areas of law that will be applicable to your disciplines or to your work in the future. Law is an important aspect of what you are going to be doing. You have to understand, for example, the principles of contracts, what contract means. You have to know how, what elements should be in a contract, so that when you come across this in your different lines of work, you will not be at a total disadvantage. Of course, as lawyers would say, this is an overview. This is, us going through this in a very surface manner, not getting into the deep aspects of the law, like we would do for law students. It's just for you to get, some knowledge of these areas of the law. So usually it will not be a substitute for legal advice or for actually consulting lawyers if you have some legal problems. But say somebody gives you a contract, based on your law of contract, what to look out for immediately in your line of work. So I was saying that, you might have had different things from people who have taken these courses in the past. What I normally advise or enjoin students to do, try and be in the classes, try and take some notes. Try to ask questions if an area is not clear to you. because what you probably find out is people saying, or your colleagues saying, oh, that law course is difficult, there are people who feel the courses, the law courses, and so on. So I want you to disabuse your minds of that, as we go through this course, and know that these are areas, these are aspects. It has been simplified to the point that you can understand it. It may not take the same structure or style as your different courses in your respective disciplines, but you'll find that paying attention, doing assignments, reading up materials, sometimes a few cases might be given or simplified, of course, for you to read and understand. And if you do, these different things, you will see that it's not such a difficult course, and it's in fact easy to pass once you get full grasp of what the whole course is about. And of course, once you are able to understand its importance to your course or your discipline, and you're able to relate the different areas that we'll be going through to your courses as well, I think that you will find it interesting and you will like it. Students do find it interesting regardless of what they say. I think that they find law very interesting, and that's also because law is interesting. So I know that you have been sent the course outline, right?
Yes, ma'am.
So you already know what the course is about, what it will cover, the expectations of the law. So we are going to cover 4 broad areas. I'm going to start today by introducing you to the Nigerian legal system. And I think as we go through, you can start thinking about how business law is related to what you are doing and what you can learn from it and why you need it. We're going to go through the law of contract. We'll study law of agency, hire purchase, and sale of goods. Like I said, today, we're just going to have an introduction to the Nigerian legal system. And that's essential for your understanding of the different aspects of business law that will follow. You have to know what the legal environment is like. When we say, contract, hire, purchase, sale of goods, and all these other aspects of law, they all revolve around our legal system. And we'll start that by looking at essentially what do we mean by law? We all take it for granted. When we talk about law, what actually do we mean by law? Does anyone have an idea of, if I say what is law, for example, are you able to give some idea, some definition of law? I also think it's important for us, to have a conversation, a bit of a two-way conversation, so that some of you don't, you just don't listen passively to the lectures. You can be engaged in the lectures. And when I say what is law, I don't mean that you have to say, you have to look for the legal definition. You can also tell me what your perception of law is. What was your understanding? So I see Fumilayo Leshi's hand up about what is law. Fumilayo.
Good afternoon, ma'am. Law is like a body of rules that a community recognizes.
Okay. So the community has to recognize the body of rules for it to be law. Is that what you are saying?
That's what I think, ma.
Okay, okay. I'll come shortly to that. I'm not sure whether we should add whether the community recognizes it or not. I mean, in some ways, we can say that the community should recognize a body of laws, but even if it's not recognized, there are people in tax, and we know how the tax system works in the way that people are not happy, they are not fond of taxes. You know what happened in Kenya recently with the introduction of a tax reform would have to obey the law, right? So that is one way to look at it, but it's also a way to open your mind to the fact that as we go through or you find different definitions, you can also apply some critical insights and look, is this definition encompassing enough? Does it really capture everything that the law is about? If people don't agree, if the community thinks that, there are issues of legitimacy, what we call legitimacy, that's kind of the recognition you are talking about, around laws that people don't accept or recognize and so on. But even if they break the law that is not recognized, for example, if it's a criminal law, they will still be punished. If it's civil law, they will still be fined and so on. So, the idea is not that you are wrong, it's to look, at what elements are present and for us to be more critical, about the different definitions you will find. And especially, for people in business, where you will see quite a number of textbooks, articles, brief write-ups that are going to tell you all sorts of things about the law and what the law is and what it is not. So for you to have, a more critical outlook, to be more critical about the different definitions that you come across. Yes, I saw some other hands up. If you want to give some other definitions or your idea, Abdul Rashid.
Good afternoon, man.
Good afternoon.
Law can be said to be a set of rules and regulation or principle guiding a country or an institution backed up by the Constitution.
Okay, thank you, Abdul Rashid. Chidera, do you still want to say something? Balogun.
That's one.
Yes.
And for me, I believe laws are guidelines meant to regulate everyday activities or operations that goes on in the country.
Okay, that's good. Thank you. Yes. Olawale.
For me, I think. Okay.
Yes.
For me, I think.
Please go on.
For me, I think law is that which is laid down, just like a rule that people follow.
Okay. Okay. So let's look at a few definitions. There are, different kinds of definitions based on different perceptions. But what we really want to find out is how they support the functions of the law, how they highlight the function of law in the society. And like I said, if you can relate that to the business context, what does it mean? for, your different studies. Why would you need law? So we have the classical definition of law, which is usually associated with Austin's theory of law as the command of the sovereign backed up by sanctions. And so you see the sovereign here is used in the sense of when, societies were ruled by the monarchy. So the sovereign is like the monarchy. That's the pronouncement or the command of the sovereign, and is backed by sanctions. So you can begin to note what are these elements. What are the elements or the characteristics of law from this different definition. We call it the command of the sovereign. So there's some authority, right? It's backed up by sanctions. If you disobey, then there's a penalty, there's a price to pay. So it's created, they are created by authorities, they are enforced because there's a threat of penalty. There are sociological definitions of law, like somebody had said, is set of rules for common good made by those who care about the community, is rooted in the reason that the society should exist harmoniously. So law is made for the public good, right? And you can see, there's a bit of difference between these two definitions. One just focuses on it being made by the sovereign, by some authority. The other one is focusing on the public good aspect of the law, that this is to serve the society, to help the society to exist harmoniously. This is a public good kind of approach to the law. We want the society to exist in a good, harmonious way. And that's why we have the laws. And, there is a definition around what we call legal realism, which defines laws in terms of the interpretation of the law. And we'll see how that feeds, into when we look at the court system and what the courts do, how this can actually be understood as a definition. Because what it's saying is that, look, law is about what the courts will do. Law is about interpretation. We should not pretend that it is anything more, because we have a piece of law. We can't know what actually it is asking us to do or it is saying until it goes to the courts, and the courts have an opportunity to say, actually, yeah, this section of the law requires this. So until they do that interpretive work, we usually might not know exactly what the law is about and how the law works. So you can see, these different approaches to defining the law. And that's what I say about, you finding, different definition of the laws. We have law as a system of norms or rules that are created by the sovereign, and the law is hierarchically structured. Sometimes it's without reference to any moral or social standards or the kind of moral standards that people would operate with. Sometimes law does not refer to that. So, law is not made with reference to that. So you find sometimes that people might say, how is that, how is that a law? Like, it's saying people can do something which is against morality, right? Or how people perceive morality. But that's a system of law. that's another way to look at law. That it's not making reference to, how people perceive that things should be done, or it's not using the moral lens necessarily, right? The examples, for example, of culture where a woman can be made to celebrate marriage with a dead person, right? Some people talk about LGBTQ plus as being immoral, etc. But we know that there are jurisdictions where it is allowed to have different sexual orientation, to have, to have a different gender than the one we are used to or the ones that we recognize. So these are examples, sometimes when the law operates, people are like, that's not good, is that a good thing? They almost equate it to something like sin or immorality and so on. But sometimes the law does not, it doesn't work on this aspect of, it does not translate. Sometimes that happens, but sometimes it doesn't translate morals into enforceable rules. So morality, you will find, is different from law. Even if something looks really, that's maybe a little, immoral or whatever. If it's not against the law, then it will be allowed to go. So these are different ways of seeing law as a means of social control, as a system of rules that needs interpretation from the courts, as an objective set of standards that is not referring to our moral or social factors. And so all this, if you put all this together, you will find, more and more definitions of law, different definitions of law, that emphasize different aspects, right? There are those who say that is the norms of the people, there are those who say that it's what the court would do. There are those who emphasize the social good. But what we really want to focus on is, what is the function of law in society? The definition might depend on the different communities and societies. But if we look at the functions of the law, are we able to then, extract or extrapolate from these different functions actually what the law should be doing or what the law is about? Sometimes in law, we normally say, it's maybe it's easier to describe certain things or certain phenomena or certain concepts than it is to try to define it. That we should rather go to description. And that's why at the beginning I was asking you, what's your perception of law? What's your understanding of law? What do you know about law? So how does law function in the society? What are the functions of law in the society? Law is used to keep order, and that would it would align with the sociological or social control definition of law, that we need law to keep order. If we don't have laws, people will do different things, and sometimes people will act based on their own moral lens, right? They say, because I think this is right, then it is right. I can drive my car at 120 kilometers per hour because I'm a fast driver and I like driving fast, right? If there's no law saying, no, you have to go slower, you can't do more than 70 kilometers per hour, then you have people using their own moral judgment, their own moral compass to determine what they are going to be doing. Okay. And essentially, that causes disharmony and disorder in the society. We've seen the emphasis on penalties, right, in some definitions of the law. So law also functions as a penal instrument by prohibiting certain behavior, certain activities. For example, criminal behavior. We see that. So we see that it helps also to keep the society in order. Not only that, it helps people actually to follow the law. Because if you prohibit a certain behavior and there are no sanctions, there are no penalties, and you see when we get to contract, for example, there is a sanction for when you enter into an agreement with a person and you breach that agreement. Please, can everyone be muted? I have some people who are coming in and out, and their mics are not muted, and that's interfering with the, flow of my class. So we have law to keep order in the society. We have emphasized that we have law as a penal instrument, so to ensure that people actually follow the law. So when there's a breach, there's also a consequence, there's a price to pay. We have law as an instrument to promote certain defined activities. So it's not all about penalties. Law can help us to promote certain activities, and in the business sense, you can start to think of how taxation works, for example. It helps us to promote certain behavior in the society. It's not all about there's an offense or a crime, there's punishment, but there's also that we want certain activities to be promoted. We want innovation, for example. We want foreign direct investment. We want industrialization, etc. People are in tax, you can relate with, sometimes there are tax breaks, there are tax incentives to promote people or to promote investment in certain types of activities within the economy. When we enter into a contract, the fact that we want our business activities to be going on, and we don't want people to enter into contracts and not care about whether they breach the contract or not, right? We want them to perform on the contract. So we have a system of law that promotes contract. People are confident because there's a law that regulates contract, that if they enter into an agreement, if they invest money, if they agree with somebody else to do particular economic activities and so on, that this will be protected. The agreement, the terms that they have entered into will all be protected under the law. So, that means that the law also helps us to give effect to different kinds of arrangements. That follows it being an instrument to promote desirable behavior or desirable activities within the society. It helps us to give effect to private arrangements, such as contract, like I've mentioned. We have contracts like a personal contract, like marriage too. Arrangements relating to custody of children. All these are different kinds of arrangements and private contracts, which, if the law does not function to promote them and to protect them, it might be difficult for us to enforce them. It might be difficult when two people are living together, if there's no contract of marriage, for any rights to be enforced around properties and other rights that might arise within the marriage. So, law is also used to remedy grievances when people don't follow, the set down rules or guidelines, the other party, or when they breach their agreement, the other party can always seek remedy because the law is there. And so you can see that, for example, we always say to people, don't take law into your own hands, right? Because there's remedy under the law. There will be remedy in the courts. There can be remedy in alternative dispute resolution mechanisms. So the law has made all these different mechanisms available for people to seek remedy if in fact their rights are breached. So you can see that law performs functions in the public space and in the private space. So in the public space, whether it's between the citizens, the government, setting standards, setting rules about what citizens can do and they cannot do. And I've said, we can, for example, equate the sovereign with the government. When they make laws, here are the rules or the guides that you are going to follow to achieve certain things or to enter into certain, to partake in certain activities, or you are prohibited from doing this. So we can have that law in the public space, and we can have that law in private arrangements amongst people. Friends do enter into contract with each other. Sometimes family members have formal contracts between themselves, and the law does govern certain private arrangements. And you can imagine, of course, that the law regulates businesses in different aspects. So you would have, for example, contracts in insurance. You will have contracts in some people will be employed. They would have contracts of employment, right? So all these different aspects, all these areas are all governed by law. The law sets the standards by which we operate within the society. And an essential aspect of that is that if we don't follow these rules, if we don't follow the law as prescribed, there are always consequences. That's what the law uses to ensure enforcement. Okay, I don't know if anyone has any questions or observations so far. So if I ask now, why do you think as business law students you need, business management students, you need to study law? What came to you, from the short explanation that I've given? How can law be beneficial to you? Why do you think you need law in your discipline? Can I have somebody from insurance? Accounting? Yes, Abdul Rashid.
Sarah, please, can you take the question again?
Why do you need law? Why are you studying law? How do you see law, business law, as relevant in view of the functions of the law that I have just highlighted? How is law relevant to your work or your study or your discipline? Why do you think, you are in a business law class? How do you think it will help you? Or how is it relevant? So you can pick any of all these different adjectives that I'm using, or different ways of asking the question. How do you think it's relevant to your work?
Okay, ma'am. law is actually relevant because
And you are from where?
okay, from insurance.
With insurance, okay.
It is relevant because when you are doing business, you do not just want to take actions into your own hands, because once you are doing business, you cannot just say, this is how you want to do it. You must be governed, because there are going to be consequences once you breach an agreement between a customer or whoever you're doing business with. There's definitely going to be agreement, and also for to respect the person's opinion. It's a kind of mutual agreement.
Okay. Yes, that's from insurance, accounting. Do you see any relevance of law to your work or to your discipline?
Good afternoon, ma.
Yes, Priscilla.
Yes, Priscilla from Business Administration, ma.
Okay.
So, law is highly relevant and beneficial to we business administration students because businesses operate within a framework of legal regulations. So, understanding the law equips us as business leaders with the knowledge to navigate legal challenges and make informed decisions, and also avoid potential liabilities in the future, ma.
Okay, great. Any other person? Taxation?
Hello, ma.
Yes.
From accounting, ma.
Accounting, yes.
Okay. Laws is relevant. It enables businesses to enforce enforceable contracts, secure financing, and conduct transactions with confidence. Laws also ensure that businesses operate responsibly and are held accountable for their actions.
Okay. I like the fact that you mentioned that it helps to conduct transactions with confidence, right? Without the assurance that the law is supporting you, or that you have recourse to remedy if there's a problem, the confidence in business activities might not be there, right? Okay, so taxation or any other?
Good afternoon, ma.
Yes.
From finance, ma.
Okay, finance.
Yeah, you mentioned about taxation earlier. There are several ways in which government can impose some policy that are not sometimes favorable with some businesses, and there are some laws that they can actually use to back it. So in those different areas, they can make use of the law, and then during maybe while they are entering into contract with their customers to make their business to make sure they are not cheated on, or the customer holds up the end of their bargain, so they can enter into contract law and so on like that. And then there will be consequence if either of them break the contract.
Okay. Okay, thank you. Is there any other discipline that sees how law relates to them or how it can help them? Yes?
This is Ayomide from Actuarial Science.
Okay.
Okay. Law is important to the actuarial science discipline because there are some data and information that are confidential that we have to keep. So the law will guide the workers from keeping whatever confidential data or information of the organization. So.
Okay, thank you. I like that. So that's another way of looking at it, that you have obligations because of the kind of discipline you are in or your line of work. You will have obligations to keep people's data, and the law will set those parameters for what you can do with the information maybe they are confidential information, they are personal data. So you know that you have to operate within the ambit of the law when you are collecting those kinds of information. Okay, that's good. Thank you. Okay, I think we've gone through all the departments. So, yes, is somebody wanting to say something?
Yes, no, this is a Chidera from Business Administration Discipline. I believe that law can help. I believe that law can help people to know what is required of them when they want to start a business, to know the documents they will need and all other relevant information before they can start doing business. Like if you want to start a public limited company, the documents that are required to start it up. So you don't just start without the legal requirements.
Okay, so who's talking somewhere? Please, can you mute your mic? So yeah, thanks. So you can use law to determine legal requirements for not only starting businesses, but different other kinds of things that you'll be doing in the line of that business. If you want finance, you want the bank to give you a loan, there would be contracts, and there are laws guiding, what terms your contract would look like. Whatever type of business you are doing, most of the time, you need to draw up a contract. If you employ people, you give them contracts of employment, right? There would be terms on what they're expected to do, how they should work, what you are going to pay them, if you are going to let them go, what process or procedure you are going to follow. So, contract generally is key to the business activities. Regulation is key to all kinds of business activities. What should be in your contract? Who can enter into the contract, right? What principles do you have to ensure that your contract is lawful, is legal? As we'll see, people have entered into contracts which cannot be enforced, right? So you need an understanding of the law of contract to know whether you are somebody who is capable of entering into a contract. If you have a business, can your business enter into this kind of contract, right? What should be in that kind of contract? Is that contract, is it made in a way that you can enforce it? That is, you can seek remedy if there are problems arising out of that contract in the future. So these are all areas, where, these are things that you have to think about as you go through as we go through, the business law classes. How can this be useful? How is this related to what I'm doing? What am I learning from this? This is very interesting. Even sometimes the things that you do on a daily basis, you would be thinking, should these be structured? Should they be made in such a way that if there's a problem, I can I can get some remedy from the court, right? If I'm living in an accommodation, should I ensure that I have a contract from the landlord? So law helps you really to evaluate your activities, both in your personal life and in your can you still hear me?
Yes, ma'am.
Okay.
And professional life.
Sorry?
Well, you're saying something about personal life and I was saying professional
because
life.
I'm saying that these are things that law helps you with the activities in your personal, professional life, in your business, you'll be able to evaluate them more critically, determine whether, for example, should you have a contract? Because you know, if you don't have a contract, you might not have a remedy. Is this contract enforceable? Do you have capacity, or does the other party have capacity? All these are, areas that help you to understand what functions the law perform, how that functions relate to you, and to the different disciplines that you are studying. And that's why I said, as we read the definitions of law, which you'll come across, many different definitions, you can apply all your understanding of the functions and say, what is this definition talking about? Does it cover how law actually functions or operates in society? What is missing, from this definition that I'm reading or that I'm looking at? How does this help me to understand what law is and how it applies to what I'm doing? Okay, so let's go to the Nigerian legal system for us to understand what is the whole legal system about? What makes up our legal system? When we say the Nigerian legal system, everything we have been talking about, the law, its functions, how it relates to us, etc., they're all within the broad ambit of a legal system. It's the legal system that determines what kinds of laws we have, how those laws are administered, how they are going to be enforced, and what actually goes into the laws that we have, what the lawmaking process, or the subjects that we regulate. All these are within the legal system. So within our legal system, we examine the types of laws that we have. We are going to look at the court system. What makes up the legal system? We have the types of laws that we have, the sources of our laws, our court
It's a way
system.
being carried out by the legal, by the board of directors.
Who is this?
Let's
Techno
not approach
Spark 7. Can you mute your mic? Okay, so I was saying that our legal system encompasses the broad area of the types of laws that we have, the sources of our laws, the system, the court system, and how the court operates, the alternative dispute resolution mechanisms that we have. All these are also determine how businesses are run, how contracts will be interpreted, what types of laws we have, and who and what they apply to. So let's look at the types of law. We have different categories of law. We have the public law, we have private law, we have criminal laws, civil laws, customary laws, international law. These are all different types of law that operate within our legal system. Public law governs, I mentioned at the beginning that, law covers both the public aspect and the private aspect of life. So public law governs the relationship between citizens and government, or between the people and the government. And they relate to those matters of that have a public flavor or that have a public nature. It's Dauda Aduat. Is there any problem? Because I see the hand up.
Yes, ma. Ma, please, can you please come again with the types of laws? I didn't get that.
Yeah, you will get it as I move on because everything will still be repeated.
Okay, ma.
I was talking about
Okay,
the
ma.
public law, that it governs the relationships between the government and the people. They relate to activities that are of a public nature. So examples of public law will be criminal law. If somebody commits an offense, it is the government that will prosecute that offender, right? It's not the person against whom the crime is committed, for example, that is going to try the criminal. It will be the government, because a crime is seen as an offense or against the public, against all the citizens, not necessarily just the person. So it is the government that takes up the prosecution of criminals. If somebody was over speeding, hit somebody, okay, they commit murder, manslaughter, grave minor offenses. Usually the government will prosecute the offender because this is a public nature kind of offense. The administrative law, constitutional law. Some of you mentioned the Constitution at the beginning, which we call the ground norm, meaning that all other laws derive from our Constitution. Anything that is not permitted to be done under the Constitution cannot be done by subsequent laws. All other laws, they take their authority from the Constitution. So examples of public law are criminal law, administrative law, constitutional law, what we call public international law. Then there's private law that regulates the interaction between citizens or between private citizens, between individuals, businesses. So sometimes they set default rules that addresses the balance of powers between individuals that are not operating on the same level. So that's why, for example, you can have contract so that one party who has more power does not go away and say, this is what I want to do, and that's it. The parties have the opportunity to negotiate, reduce their agreement into an enforceable contract, and then go to court for remedy if there's a breach of that agreement. Please, edit. Edit, can you close your microphone, please? Okay. So we have public law, private law that deals with the interaction between individuals, between private citizens, the agreement that they enter into, contract that we are going to be dealing with. Much of the laws that we are going to be dealing with, the areas we are going to be dealing with, are going to be on private law. When we deal with contract, you will see how this can be an agreement between two people, two entities or more, and how they are agreements and how they must be agreements that the law would enforce. And I said that law comes into that private space because sometimes parties have more power. There's imbalance of power. So the law tries to level out the influences of the party. So one party having more power does not overreach the other party who has less power. An example can be employment agreement, right? If somebody wants a job, maybe they need this job really desperately, and you can give any condition. The employer can give any kind of condition under which they would work or under which they will employ them. If Oluwatoyin Christiana. Find this person. Unbelievable that some people are actually listening to the class on the bus. I don't know how that will work. Okay. I have muted all now. Okay. So I was talking about private law and how the importance of law in the private space or in private agreements or transactions. And one example is that it helps to set default rules so that parties can address power imbalances. And I was giving an example of employment agreement or employment relationship, where if the law does not set certain default rules, you might have one party taking advantage of the other party. And so if we have these two different, broad types of law, then we have examples, of laws that fall under public or private law. I've given you an example of criminal law, administrative law, constitutional law as examples of public law. In the case of private law, contracts are examples, different types of contracts of employment are also examples. But contracts more broadly are examples of private law, family law are all examples where you can have, the law come into private spaces or private transaction to set the rules that people will follow even in their activities. Yeah, property law is an example of private law as well. Property are usually owned by individuals or other legal entities that are recognized by law. So you would also come across, terms like criminal law and civil law, where criminal law is that aspect of public law. I've given that as the example that deals with prohibiting certain kinds of behavior and conduct within the society, and it imposes sanctions. It's an essential aspect of criminal law that there should be prohibition of that activity. Don't do it. And if you do it, there would be a punishment, or there would be sanctions or penalties. That's an example of criminal law, or what criminal law does. And it's the states, like I mentioned, that prosecutes criminals. And you would also come across, terms like civil law, which relates broadly to all aspects of the law that are not criminal in nature. So they're covering, actions that are initiated by private citizens in court. If there's a breach of contract, one party takes the other to court, that's a civil action, right? If somebody drives their car above the legal speed limits, that's a crime. And it is the government that will prosecute the criminal. When there is a breach, the individual who has been wronged will take the action to court. So far I've mentioned public law, the private law, criminal law, and civil law. Is there anyone having a question? So you also come across when you read up or you hear about types of law, customary laws and international law. So customary law is usually a collection of norms of the people, the things that people value, which are recognized and enforced. Somebody did mention that at the beginning, right? And you can see the first definition of law that we had from the class, how that fits into the law, but in a narrow way. So the laws that people, the values or the norms that people agree should govern their space or their communities and so on. This is the ambit of customary law. People have a set of values that they recognize from their customs and practices. Sometimes that is not enacted by the legislative arm of government. It's not an enactment of the legislature. It's not written in law. And that's why, for example, you can't have customary, like customary crime. You can't have criminal law. You can't commit a crime under customary law because it's mostly unwritten, and the punishment for that crime is also not prescribed, or at least it's not written in the criminal law. So usually this will be a set of values that people hold there, and which they agree should govern certain aspects of their life, like there's recognition of customary marriage, right? Where men can marry 2, 3, 4, 5, 10, etc. number of wives, because the customs of the people recognize that kind of practice. There are customary rules governing inheritance, there are customary rules around mediation. If two people have a dispute, customary ways of settling those disputes are recognized. And that's usually the oldest form of laws, and those are the kinds of laws where you have an agreement of sorts, about this collection of values and norms that the people value and agree that should govern certain types, certain aspects of their lives or certain activities. So I've said that customary laws usually apply with certain limitations. Example is in criminal law, where the offense should be written and the punishment should also be written. But because customary law is largely unwritten, it cannot apply in this kind of situation. So there's also international law, which is also a collection of rules governing relations between states, between countries. So you have examples in international treaty, and this can also be, as we'll see shortly, sources of domestic laws. That's domestic or national laws that apply within a country like Nigeria. Sometimes these laws are based on international agreements or international treaty and international law systems, because they want a kind of harmonization around certain kinds of activities that concern states or businesses or individuals, like human rights law, right? They want a standard for everybody. This is the right of all human beings. So each country can go and implement those standards in their own law and accept that international framework as the one that would also govern the country, that would also apply within the country. So these are the different types of laws or the categories of laws that we have. I don't know if that is clear. If anyone has any questions around this area of the law. Okay.
Hello, ma.
Yes.
Good afternoon, ma. I have a question concerning the private laws. So, in the private law, is it legal for private individuals to seek legal backup when entering into an agreement?
Okay, I'm not sure I fully understand your question. What do you mean by law?
I said, like, if two private individuals, which are citizens, entered into contracts, I said, is it compulsory to get a legal backup, like a legal stamp on their agreement?
I'm not totally sure, but let me try to. Are you saying that if they enter into an agreement, that the formal process of applying some, kind of thing to the document to make it enforceable? Is that what you mean by legal backing? Because yeah. So because you see as we go on that the law does recognize even agreements that are not written, right? So contracts can be made orally or in writing, and we'll see what needs to be present, the elements that need to be present, and formality of the contract is to ensure that the parties, to increase the confidence of the parties, but it doesn't mean that the law will not enforce the agreement because you did not put some kind of stamp, unless that is the prescription of the law. There are certain kinds of agreement. The law requires that you should register those kinds of agreement before they can become enforceable. And we'll see examples of those. So is that clear? There are circumstances under which you make an agreement is oral, but the law can make an inference. It can draw an inference or a deduction that these people intend to be bound, even though they have not reduced the agreement into writing. But there are agreements that the law requires. It prescribes that those agreements must be in writing, those agreements must be stamped, they must be signed, sealed, they must be registered, etc. And we'll see examples of that. But broadly, you don't need a formal process for the court to find that there is a contract between two parties and to uphold that contract, right?
Yeah, thank you, ma. Thank you, ma.
Okay.
Good afternoon,
okay.
Ma.
Yes?
Please, ma, I want to ask, is there a connection between civil law and private law?
Between
civil law and private law?
Definitely. Civil law is all types of laws that are not criminal law, because criminal law is distinct, like I've explained. Private law will be a type of civil law because you take civil action, right, to enforce a private right. You don't take criminal action. You go to the civil court to enforce your contract with another party. You don't go to report to the police like you do if a car was stolen, if somebody assaulted you or another person, you simply take a civil action, right? Because a civil action, you can get damages, right? if there's a breach of contract, the court can order the party, go and perform your part of the contract. You have failed. You have to perform it, like what we call specific performance. The court can award you damages because you have suffered as a result of that person's unwillingness, failure, neglect, recklessness, etc., to perform their own part of the contract. Is that clear? So broadly,
Yes,
all types of any kind of law or any kind of action that is not criminal would usually be civil in nature, whether it's relating to family, contract, property, intellectual property. All these are civil actions, between individuals. Okay, so let's look at the sources of law briefly. What are the sources of our law? Like I said, all these are parts of the they are all part of our legal system. They are the components of our legal system, the different types of laws that we have, and the sources of these laws. Where do we get our laws from? Where do they come from? Right? We have acts of the National Assembly, what we call statutes or legislation, laws that are passed or made by the National Assembly or the state's houses of assembly. And the Constitution, like I mentioned earlier, is the highest and most important law in this, in this context. We call it the grown-up, and it just set out general principles of law, without setting out the specifics of how they are going to be implemented or achieved, right? So the Constitution can say the federal government can impose certain types of tax. Then you have different tax legislations that are passed to ensure that this tax can be collected, who is going to administer the tax, how it's going to be distributed, what percentage is going to go to X or Y, right? The Constitution can recognize the protection of people's rights, their intellectual property right. Then you have intellectual property, different types of intellectual property laws, like copyright law, law on patents, trademarks, and so on, that help to enforce that law, that sets out the guiding or specific principles that are going to be needed to achieve that principle, standard that is set up by the Constitution. So anything that the Constitution prohibits or the Constitution does not recognize can actually not be implemented. The legislative authority, like the National Assembly and the state houses of assembly, they can't implement that if there's no constitutional power to make laws on those or to implement certain aspects of the law. If something or a right or an activity is not recognized, protected by the Constitution, then we can't have the laws that are going to help us to achieve that. So the Constitution is the ground from which all other laws, all other acts of the National Assembly derive their legitimacy. So that the legislature creates different types of law based on the Constitution. And like I said, we have both federal houses, we have the state houses, and the federal lawmakers make laws. The National Assembly make laws that are applicable to the whole of Nigeria, while states make laws that are applicable to the respective states. So one major source of our law is the acts of the National Assembly. And you see that the National Assembly has over time amended the Constitution, right? Because the Constitution itself is a kind of law. Okay, so we also have in our system what we call the received English law. Most of you will know that Nigeria was colonized by the British. So before the British left, before we gained independence, they had different kinds of laws that were used in England, which they also brought into which they also brought into Nigeria as colonial powers. So we have what we call Statute of General Application. These are laws that were applicable in England and they were enforced as at 1st January 1900. All these laws were automatically applicable in Nigeria. Some of them were amended, some of them were no longer used, but they constituted the source of our law. Once we've replaced them with an act of the legislature, the parliament, that is the National Assembly, then they cease to operate in Nigeria. There are what we call common law and principles of equity. And we come across that, now and then when we read some cases, when we examine some principles or doctrine in contract, we will say at common law, this is done. But equity has come to actually mitigate those kinds of difficulties. So the principles of common law and doctrines of equity were also received in Nigeria. And common law were laws that were developed by the judges of the King's Court in England. And the purpose is for them to resolve certain kinds of disputes. The common law has procedures laid down. They have course of action, and anybody coming to the common law court must be able to fit their complaint or their dispute within the actions that are recognized by the common law court. Once they can't identify their course of action within that system, then they cannot bring the action, and that means that they have no remedy. So they must be able to claim, remedies that are available. Otherwise, if there's a wrong, there won't be a remedy. So this, the way that I'm saying it, maybe is occurring to you, this is a very rigid system, that is not allowing for flexibility. When you are coming, there's a set of principles, there's a set of action within which you can bring your complaint. If your complaint does not fall within that, you have no complaint. There are a set of remedies. If you can't bring your remedies within this, this set of principles that have been set, these rules that have been developed by the judges, then you can't have a remedy, you can't have a course of action. So that sounds very tough and very rigid. And that's why the equitable remedies or equity came into play to ensure that sometimes, even when people cannot bring their action or remedies within the common law, they can still have some, their wrongs can still be remedied. So, like I said, we'll come across these phrases now and then where we say at common law, this is what obtains and is possible. But because of equitable intervention, the parties could actually get some respite. So in the next class, we'll just look broadly at the doctrines of equity, and we look at the court system and hierarchy, and the alternative dispute resolution, under our legal system. And hopefully we can then start the law of contract. So I think we can call it a day, and I hope that the next class we can really start on time and have everything in order. So thank you for your attention. Is someone raising their hand quickly? Okay. So enjoy the rest of your day and thank you for your attention. Bye-bye.
Thank you, ma.
Thank you, ma.
Thank you, ma.
Thank you.
Vamos.
Thank you,
so
ma.
much, ma.
Thank you.
Thank you so much, ma.